You're either going to get out of the car or we're going to drag you out.
Drag me out.
All right.
What? 6, I'm clear with the crash report. I'm headed over.
Get out of the car, dude. Get out of the car. You spit on us, we're going to have a problem.
Make me.
We're going to have a problem, child. Don't worry.
Don't worry. Get me out of here.
What's your last name?
Figure it out.
Okay. So you're refusing to identify yourself?
Yes, I am.
Okay. That's fine.
On November 24th, 2023, officers in Illinois responded to a highway shoulder welfare call a man found unconscious beside the road following a prolonged seizure. What began as a medical response became a 5-charge criminal arrest, including a Class 1 felony.
Is the back door open?
The window's open.
Nah, don't worry about it.
That's a guy, I don't want to touch him. Okay.
Hey, brother. You all right?
Yeah. You want to open it?
Yeah.
I'm going to shut the back door open. Thank you, sir. Sorry about that. Yes, sir. I don't know.
He stopped seizing. He was seizing for a good 8 minutes.
Hey, man. Hey, what's going on? Do you know your name?
Yeah.
What's your name?
We were just driving and we stopped.
Okay.
Found him.
Hey, are you able to move out a little bit?
Yeah.
So paramedics can talk to you?
Hi. Okay.
He was, I don't know if he was.
Did anybody actually witness this accident?
No, we
Okay.
came up, but he was seizing for a good 8 minutes.
Okay.
I was looking to see
Yeah.
where he came from.
Okay.
911, she has my number. My office is right over here, so if you guys need anything.
Okay. Sounds good. Yeah, I mean, as long as nobody witnessed it,
Yeah, no, we just rolled up on
I'm not going to take any information, but I appreciate you guys calling, okay?
What's your name?
Yo, man, you got a wallet? No.
Hey, is anything hurt? No? Do you remember what happened? No?
Hey, sir, what's your first name?
Yeah.
Where's your wallet? How much you had to drink, brother?
What?
How much you had to drink, dude? What's it?
It's enough for that much.
Not that much? How much is not that much? One, I see your beer here. How many? 1, 2, 3, 4?
2.
You had 2 beers? When did you have those?
Early.
Okay, so it's 8 in the morning right now.
Can you arrest?
What time did you have those?
Morning.
In the morning? Okay. Hey, do you got a wallet on you, man?
Can we get you out of the car and under our stretcher? Let's go in the warmth, okay? Can you slide your legs out? Well, you can't slide your legs out?
Okay, 10-4.
Come on, man. Let's go. Then get out of the car. Listen, get out of the car.
You know, you're not gonna swing.
Come on.
Listen, I'm gonna swing.
What's your name, buddy? What's your name? Here's your whole fire department.
I'm cold too.
We gotta get you back to the ambulance. You're shaking. You're cold, bro. Dude, come on, let's go. Hey, you swing a hand, your day's gonna get really bad really fast. Come on.
Are the keys out of the ignition?
Come on, dude. Come on. Let's go.
Waylon, how old is Dylan?
How old are you? What are you? I mean, you're acting like you're 10, but how old are you?
Just watch out for this.
What are we doing? I'm dragging him out.
You want to drag me? So the guy, I'm gonna show out, bro.
Buddy, you're
What does that even mean?
I'm gonna show out, bro.
What does show out mean?
I don't want to drag you. Show out, bro.
What does that mean? Let's go.
Yo, look, dude, you're not gonna be fighting my paramedics. Get out of the Get out of the car. Get out of the car. You're gonna get out of the car. We're gonna drag you out.
Drag me out.
All right.
Well, 6, I'm clear with the crash report. I'm headed over.
Get out of the car, dude.
One of the other units can.
Get out of the car. You spit on us, we're gonna have a problem.
Make me. Make me.
All 4 tanks.
We're gonna have a problem here.
Make me. Make it. Make it a problem.
All right, we'll get you out. Don't worry.
Okay, don't worry. Get me out of here.
What's your last name?
Figure it out.
Okay. So you're refusing to identify
Figure it
yourself?
out. Yes, I am.
Okay. That's fine.
I have no problem with identifying myself.
Whose car is this?
Don't worry about it.
Okay.
Let's get you out of the car. There you go.
I promise you. I'll sue you. Don't sue me.
Hey.
Don't touch me.
Hey,
Sit down. Sit down.
Hey, don't touch me. Don't touch me. I don't have no structure for any time. Don't get me off me. Don't get me off me.
Alright, bend back up a little bit. Knock it off, dude.
I'm not doing shit, bro. Don't arrest me for no reason.
We're not arresting you. We're taking you in the ambulance. So you can get the ambulance.
I got one on him.
Right? No, we're not arresting me. Okay,
Put your hands behind your back.
Yeah, that's because you're not helping yourself, dude. We're
I heard nothing to say.
Oh, one. I got one in cuffs.
We don't have. Hey,
I heard nothing to say to him. I'm saying right now, when I see y'all, I'm gonna sue you.
okay.
I'm gonna sue you.
We're gonna get you warrant.
You want to bend that?
I don't even know what that means.
Sue me. So much.
What does that even mean?
I promise you.
What are you, 6 years old? Give it a break.
You got me. Okay. You got me up. I ain't going nowhere. I ain't going nowhere.
Lean back.
No.
We do have his feet.
You got me up. I ain't going nowhere.
Let's get this on.
I ain't going nowhere. You got me up.
Hey, you guys got a... But we do not know. We don't carry those.
But we can put a mask on the pocket.
Wait, I want that one.
Because
he's gone.
Sorry.
Yeah.
Do you guys carry those or no?
Go ahead.
Somewhere, but...
Ready?
Yeah. Up. All right, back.
No one is bringing me when
Oh, all right.
my arm.
Here, let me do.
We're gonna have to.
We just get
I think she wants us to.
I want y'all to treat me.
I
want y'all to treat me.
All right.
Why wouldn't you say that?
I want to be treated.
So we're going to take one in the back. We're not going to treat his blood sugar because we do the oral, which he already spit out. But we're not starting the line on him. So we're just going to go.
Can you guys throw a mask on him? Because he's going to spit on somebody.
We're actually,
Yeah.
if you want to do that. We're just all going to be behind him. We don't have anything. He's going to keep on because we have the...
I think it's better because it's
Hey Jesse, what's up, man? I'm Deputy Dickerson. We're trying to get you in here, get you through the process so you can go to court, get everything figured out. You gonna be cool with us, man? Yeah. You're not gonna fight or nothing like that?
no, that's cool.
You cool? Enjoy it.
The initial officer contact falls squarely within the Aachen. community caretaking doctrine established by the Supreme Court. In Cady versus Dombrowski, tysiąc dziewięćset siedemdziesiąt officers may make warrantless contact with individuals in medical distress on public roadways. No Fourth Amendment violation exists at this stage. The encounter is a welfare check, not a seizure. Once officers observe open alcohol containers and the subject displays signs of impairment, disorientation, inability to remain awake, incoherent responses, the encounter lawfully elevates to an investigative detention. Under Terry v. Ohio, 1968, reasonable articulable suspicion has been established. Under Illinois Statute 625 ILCS 511-501, proof of DUI does not require a breath or blood test. Observable impairment satisfies the evidentiary threshold. The subject's condition, combined with open containers visible in the vehicle, creates independent probable cause for both DUI and a violation of 625 ILCS 511-502, transportation of open alcohol. The order to exit the vehicle is constitutionally sound. Pennsylvania versus Mimms, 1977, established that officers conducting a lawful stop may order the driver from the vehicle. As a matter of course, the intrusion is de minimis, outweighed by officer safety interests. Refusal to comply is not a legal option. It is obstruction. The subject's repeated statements, "I'm going to swing," require legal classification. City of Houston versus Hill, 1987, protects offensive language directed at law enforcement under the First Amendment. However, that protection does not extend to conditional threats of imminent physical violence delivered at close quarters. "I'm going to swing" is not protected speech. Under Illinois law, it constitutes a criminal threat. The subject spits on officers. This is not a misdemeanor. Under 720 ILCS 51223.05 D4, battery of a peace officer, including any physical contact of an insulting or provoking nature, constitutes aggravated battery. Classification: Class 1 felony. Sentencing range: 4 to 15 years in the Illinois Department of Corrections. A single act of spitting transforms this encounter from a misdemeanor arrest into a felony prosecution. The subject explicitly refuses to identify himself on camera. Illinois Statute 625 ILCS 5-6-112 requires any driver to present a valid license upon an officer's demand. The subject's statement "figure it out," combined with his later admission, "yes, I am," when asked if he was refusing to identify, constitutes obstruction of a peace officer. Under 720 ILCS 5-3-1-1, a Class A misdemeanor. The refusal is documented verbatim on Bodycam. When officers initiate physical removal, the use of force is evaluated under Graham v. Connor, 1989. The standard is objective reasonableness, judged from the perspective of a reasonable officer at the moment of the decision, not with hindsight. Factors present: a confined space, repeated violence, threats, refusal of multiple lawful orders, and close proximity to paramedic personnel. The force applied is proportional. The subject's threat to file a lawsuit, once restrained, is constitutionally protected activity. The First Amendment protects the right to threaten civil litigation. Officers correctly do not respond with additional force. This distinction is legally significant. Verbal expression of intent to sue is not obstruction, not battery, and provides no grounds for additional charges. At processing, the subject is charged with 5 offenses. First, resisting a peace officer, 720 ILCS 5-3-1-1. Second, transportation of open alcohol, 625 ILCS 5-1-1-502. Third, operating without a valid license, 625 ILCS 5-6-101. Fourth, aggravated battery of a peace officer, 720 ILCS 512-3.05 D4, Class 1 felony. Fifth, driving while intoxicated, 625 ILCS 511-501. Law enforcement receives a B+. Officers made sustained de-escalation attempts across several minutes before initiating any physical contact. Medical priority was established correctly upon arrival. Physical removal, when initiated, was proportional under the Graham v. Connor standard. The spit mask protocol discussion reflects policy awareness. 2 areas for improvement: tactical positioning during vehicle extraction lacked optimal reactionary gap discipline, and the formal transition from welfare contact to investigative detention could have been articulated earlier once DUI indicators became apparent. Overall, measured professional conduct in a high difficulty encounter. The subject receives a D. Mitigating context is acknowledged. The subject had experienced a prolonged seizure immediately prior to the encounter. Postictal disorientation is a recognized medical state that impairs cognition and emotional regulation. This is a legitimate mitigating factor. However, the footage documents deliberate conduct. Threats of imminent violence stated multiple times with specificity. Spitting on officers, a Class 1 felony if proven. An on-camera, explicit refusal to identify stated as a conscious choice. Sustained refusal of lawful orders across an extended period. The subject verbalized awareness of legal consequences. He threatened lawsuits, referenced officers by role, and articulated grievances coherently. Confusion does not explain the pattern. The choices documented on camera resulted in 5 charges, including a felony that carries up to 15 years imprisonment. 3 lessons from this encounter. First, a single physical act, spitting, converted a misdemeanor arrest into a Class 1 felony prosecution. The legal threshold between misdemeanor and felony in law enforcement contacts can be crossed in 1 second. Second, explicit on-camera statements carry evidentiary weight. Yes, I am confirming refusal to identify is admissible, unambiguous, and eliminates any factual dispute. At the obstruction charge, what a subject says on Bodycam becomes part of the prosecution's case file. Third, de-escalation has legal and tactical value beyond optics. Officers who exhaust verbal options before applying force build a documented record of proportionality, a direct offense against future civil liability under Section 1983. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching.